Yeah, hi, small business owners. It's Harpreet Singh from Shareholder Law Firm. Today, I want to talk about a very important document. In the previous video, we discussed about the documents which are important in the corporation, and one of the important document is a shareholder agreement. So, what's a shareholder agreement is? As its name sound, it's an agreement between shareholders. But it's not just agreement within shareholders, it also involves the corporation itself. So this agreement provides the terms and also some rights to the shareholders, basically in terms of selling their shares, buying their shares, and in a situation where some third party want to enter as a shareholder, and if you want to allow that transaction to happen or not, or who would have the right to buy those shares. So all those transactional rules, you would be able to have those in a shareholder agreement. And why it becomes important? Because suppose you are a small business owner and you have three family members as your shareholders, and if suppose something happens financially to one of the shareholders, and that shareholder want to sell it to a third person which is outside your family, and I think people get nervous because when someone comes in from outside you don't know him about, and this person now has this right to own this business, he would have decision making rights and I think so much power, which a shareholder, and ultimately he can be a director. So people get nervous, especially in a family business, to bring other people from outside. But that doesn't means you are a shareholder, you don't have like you would not just remove someone's right to not own certain share and sell those shares later on, because then it doesn't have much value in it. So if you own shares, then it needs to be have that right of selling those shares later on. So while keeping that right and also balancing out within a family business, you can put a restrictions in shareholder agreements. Either you can just completely prohibit any transfer of shares outside the family or outside the existing number of shareholders. That may affect your value because there is only so much pool of shareholders that you would be able to sell your shares to. And when there is a less pool of buyers, the price goes down. So usually how it's structured, that if suppose you get an offer from a third party, the corporation would have a first right of refusal in terms of evaluating that offer and making a decision that, first of all, the corporation would be able to buy your shares, give you the money, and take that share back with the corporation. That's one of the options. If suppose the corporation in itself doesn't have that kind of a funds in their bank account, or don't have the assets to take loan on, because sometimes you are already prepared with your future development I think purposes, or for any kind of ongoing operational expenses, you need those money in your bank account. So the corporation cannot just pick the money from the bank account and give it to the shareholder and buy these shares without thinking about the operational needs and also future developmental needs of the business. So if suppose the corporation, and ultimately the decision would be taken by the board of director, not the interested board of director. If suppose one of the shareholder who is selling their shares is one of the board of directors, that board of director obviously will not be a decision maker because he is an interested party, and you want to make sure that there is no conflict of interest in that decision making process. So first the corporation gets one bite of the apple, and if they want to take that bite, they will accept the offer, and the transaction will, I think, happen about purchasing these shares. So what about if the corporation doesn't want to get these shares? Then you can again structure in a way that the next step would be that the other shareholders will have the opportunity to accept that offer. So you can structure in a way that the same and similar offer, as it works in any kind of real estate transaction. You have seen first right of refusal. You just present that same offer, and if that offer is acceptable, whoever person who have that right, then he will pay you based on that legitimate good faith offer from other third parties. So it works in that similar way. So the other shareholder would have the opportunity to accept that offer and just try to increase their interest in this particular corporation. But let's think about a situation where suppose the shareholder died, and in this situation it's unanticipated, and now you have successors of this shareholder who just want to sell their shares because they don't want to continue owning anything in this corporation, and they just want that financial freedom in itself without, I think, just putting their interest in this corporation. Or there can be many issues in regards to someone don't like someone in the family, so maybe there is not, I think, that good relationship among themselves, so they want to sell those shares. So the situation is that who they will sell those shares to. Obviously in that situation, because the situation is so urgent, because it's a death and family members possibly need finances. So in that situation, usually how a shareholder agreement is structured, even before that situation comes in, that the corporation will take out insurance policies on all the shareholders, so that if suppose one of the shareholder died, the corporation would be the beneficiary of those insurance policy, so that the insurance policy can be used to buy these shares. So you can understand how creative financing mechanism that is. So the corporation doesn't have to touch their own bank account, but still they have finances to purchase these shares. The successors are happy because they are paid, I think, completely with this life insurance proceeds. Corporation get those shares, and the shareholders who are still within the corporation, they are also happy that some other third person who we don't have much good relation with or we don't know about is not becoming the owner of this corporation or not taking those important decisions. So you can see with that creative mechanism, you can able to buy those shares, still make the family members whole, and also the shareholders, the existing one, doesn't have any worries to think about. So that's about the death. And let's see if suppose there is no situation of death and there is no offer in place, but there can be a situation like, obviously human beings fight. They don't like someone's ideas, or someone is doing something which they don't like it. Or if you can think about, a person is in a situation that they are trying to compete, or you think that in future they will try to compete with the corporation's business, and you don't want that person to be in this corporation, but this person has, like, suppose 30% interest. So what you will do in that situation, so you can structure to remove that person, or you can, in loose language, you can say, if you want to kick out that shareholder from your corporation, you can have a buyout provision. So basically a buyout provision can be, you can make the offer to that shareholder, and that shareholder has to accept that offer. Means it's kind of a one-sided offer. You just make it, he have to accept it. However, he have one option, because you would be thinking that means he would be making him an offer of like 1 cent per share, which is ridiculous. with this like one-way situation, he can just say, okay, I'm offering you 1 cent per share and just give me your shares and I want to buy it. But the another provision which will stop it and balance it out, that the offeree in that situation have the option to buy the shares of the offeror. An offeror, it's just the technical words. So I will just say in simple language. So the buyer of this transaction have the option of buying those shares at that same price which is asked by the seller. So you can understand. So the seller will not send you an offer with 1 cent per share, because he would have concern that this person can buy my shares at the same price. So this is a provision which balanced out it, and you can also put other barriers to it so that there will be no unfair situation, or there would be no, I think, situation happening where you have not even anticipated a price. But I think this situation balanced out itself. So I think by looking these three situations, you would have understand that how important to have these kind of agreements in place. Because when your business is small, I can understand people don't care much about it. But when you grow your business and you have 3-4 shareholders in it, then it becomes, I think, an important question about who should progress with this business. The person who is providing a good performance, or a person who is doing nothing. So that question comes in when you are trying to make money. So it's always good to, I think, structure those relationships with these kind of provisions. And some of the bylaws have those provision in them if it's extensive enough, but it's always good to have a separate agreement which is talking about in detail how these transactions will take place, what would be the rules. Number of days are important because you don't want to give fewer days to think about an offer and to accept an offer, and not to think about the consequences of it, your finances, your future budget. So all those rules will be in the shareholder agreement. And also you can include in shareholder agreements, obviously, your rules about the meeting of shareholders. And in addition to that, you can also have voting agreements, like how the shareholders will vote in future on a particular topic. You can have those agreements ahead of time before it comes to the agenda or meeting of the shareholders, so that you have those block of shareholder which you already know they will not vote for this kind of change in your corporation. You can have those agreement, you can structure all those rules in the shareholder agreement. So it's very important to have shareholder agreement. If you are thinking about, you will add more and more people in future. So I think always think about it, have consultation with legal professionals whenever you are thinking about that. You are, I think, at least I will recommend you, when you have like 2 shareholders, at least just start from there. So at least you will understand what are the rules, and in future you can always amend and add new shareholders in, so that you don't have any issues. Because when the issues will be coming up, you cannot go back, and no one will signing these rules which are not in their favor, obviously. So you need to have these agreements in place beforehand. Again, thanks for watching these videos. Thanks to Mr. Basi, Lourdes, and Alex. Thanks again for watching these videos and supporting it. And probably you would have, I think, little bit of legal knowledge, at least to, I think, start with a good conversation with your legal professional, so that you are not putting more time in to understand these things. Thank you. See you in the next video.